Good evening, ladies and gentlemen. Welcome to the Toronto Debating Society. Today, February 22nd, 2011, the Ontario Human Rights Tribunal must be abolished. We will start our debate by our Prime Minister, Dave. Please.
Thank you, Mr. Speaker. Ladies and gentlemen, the Ontario Human Rights Tribunal must be abolished. Now this sounds pretty ominous, and human rights sounds good, and why would we want to be abolishing something that has to do with human rights? Well, I'll be happy to tell you. So first of all, the Ontario Human Rights Tribunal. This is an arm of the Ontario Human Rights Commission that was created in 2008 after the Ontario Human Rights Code was so amended. And must is necessary, and abolished is get rid of or do away with. Now, some background. This tribunal is an arm-length government agency that deals exclusively with cases of discrimination or harassment. And now we've got some relevant sections of the Charter to set the stage here. So first of all, Section 2 of the Charter says that everyone has the fundamental freedom of thought, belief, opinion, and expression. But then, Section 15 says that everyone has the right to be free of discrimination, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. Now, we have three arguments we're going to go into here. First of all, this is unfair. The tribunal is absolutely unfair, fundamentally flawed. Second of all, it is expensive. Third, it doesn't even do what it's supposed to do. Now, first of all, about its being unfair. The tribunal conducts hearings and renders judgment with the force of law. However, according to their own guidelines, they don't even have a consistent process. Quote, the procedure used in each hearing may vary. Now you would never ever see that in an actual Canadian courtroom. The procedure used may vary. What this actually means is it gives the adjudicators in these tribunals extraordinary powers to use, quote, non-traditional methods to question witnesses, limit evidence, and receive testimony without oath. And in one example, in Norman Traversy versus the Human Rights Tribunal of Ontario, the tribunal itself doesn't even really care about conflicts of interest. So in this case, this applicant charged that the services offered by the tribunal were discriminatory against those with disabilities. Now, not surprisingly, the case was dismissed, and no comment about conflicts of interest. You'd never see that in a real courtroom. And also, about it being this para-kangaroo kind of court, the tribunal doesn't even consider normal legal grounds for appeals. So sometimes, in fact, I'm sure you're going to hear a lot of good things from the opposition about things that the tribunal does that's great. Like there was this case where Michael Greziak, he brought a claim against his employer because they terminated him because he could no longer work because he had a disability. And yes, he received remittance for being terminated for that. However, the employer, they brought forward an appeal, and the appeal was based on the fact that they made 9 errors of fact and law. Now, this would be grounds for an appeal in a normal courtroom. We all might want to say, well, it seems to be open and shut case, but the appeal should still be allowed to go through, except the Ontario Human Rights Tribunal, the adjudicator, said, quote, well, this process is not an appeal in the usual sense of the word, unquote, and then just dismissed the appeal. So they use whatever grounds they want. So it's just fundamentally unfair. And according to their own guidelines again, the committee is not intended to be a forum for the discussion of substantive issues of law, unquote. So in other words, sorry, just flimsy ones here. That's it here. And to continue talking about why it's unfair, the OHRT they've expanded the criminal code's definition of discrimination and harassment. According to the code, criminal harassment is to engage in conduct that causes the other person to fear for their safety. Now, what the Human Rights Tribunal does is they've expanded that to talk about these flimsy discussions about humiliation, hurt feelings, loss of self-respect, dignity, and confidence. Sure, yeah, these are bad things. However, is this really something that you're going to be brought in front of the tribunal for hurt feelings? This is not something we want to have in a court of law. Now, second of all, this is expensive. Now, all of these crazy things, if you're going to bring someone up in front of a court about having hurt feelings, that's fine. Hire your own lawyer to do that. However, when you go to the tribunal and you want to say, well, this person hurt my feelings, the tribunal will say, okay, we'll take your case. Because even if your case is groundless, what the tribunal will do, according to its own guidelines, is to help build a case for you. And they will pay for their own lawyers, they'll pay for everything. It won't cost you a cent. In fact, the tribunal cost the taxpayers of Ontario $7.8 million in 2008, and it didn't recoup any funds. That's right, this is absolutely free, and we will put everyone up to the bat for you. And the reason why Canada is different than the US, why we have less frivolous lawsuits, is because we have the loser pays argument. You can be awarded with costs. Now, with the tribunal, that doesn't happen. You can't win costs. If you are charged with hurting someone's feelings, you have to hire your own lawyer, you are not offered any government assistance or legal aid, and then there is, even after spending a lengthy trial, spending maybe $750,000 like McLean's did to defend itself against a frivolous case, they don't win their money back. So there's absolutely no negative repercussions for bringing frivolous lawsuits. And now this follows into my third point about it doesn't even do what it's supposed to do. If this tribunal is supposed to free up the pressure from the real legal system of these cases that can go into it, well, we have a bit of a problem because they have a very slow pace of resolutions. I'll give you some statistics here. In 2008, about 1,700 new applications were filed, and there was already an existing 1,400 applications, so they had about 3,000 applications that year. Now, that year, they only handed out 400 decisions. And of those 400 decisions, 300 were only interim decisions, as in we're not through with this yet. And according to their own projections, they are going to be running into about 3,000 incoming applications a year. So they are not going to be able to catch up. This is just going to force the Canadian taxpayer and the taxpayers of Ontario to pay through the nose for these protracted legal costs. Finally, part of what doesn't even do what it's supposed to do. The system is absolutely riddled with these nuisance claims. Now, the following examples, they will speak for themselves. So, Kenneth Moratillo versus the Ministry of Transportation. This applicant, he brought the Ministry of Transportation in front of the tribunal because his license was suspended, but his driver's license was suspended because he had a disability. That disability was alcoholism. And there was another case where Hao Soon Huang was wrongly brought in front of the tribunal, and she says, well, my employer wouldn't let me take my lunch break with the other employees there, and so there wasn't very much food left. This is reasons, it's difficult not to find these nuisance cases. You just keep looking at them, and they're all there. So, to conclude, the tribunal is unfair, it's expensive to the taxpayers, and it does not even do what it's supposed to do. Ladies and gentlemen, please support the motion. Thank you.
Thank you, Dave. Now, the leader of the opposition, Adrian.
Thank you very much, Mr. Speaker. The government has come forward and presented a somewhat weak, if not totally devoid, case of the facts as to why the Ontario Human Rights Tribunal should be abolished. They give 3 reasons. 1, it's unfair. 2, it's expensive. And 3, it doesn't do what it's supposed to do. The opposition is going to tackle those points head on. First, it's unfair. The government has brought, several charter, has quoted several acts of the charter saying that pretty much the charter guarantees these rights, so it's not really necessary. However, what the government hasn't told you is Section 32, which says that the charter only applies to governments. It only applies to the federal government, and it only applies to provincial government. It does not apply to municipal government, and it does not apply to individual actors, meaning, therefore, that if they were to abolish the Ontario Human Rights Tribunal, and, for example, a bar owner had a sign saying, no blacks allowed, or no gays allowed, under that particular rule, the charter would be no use to you whatsoever. Your only recourse would be to listen to follow the guidelines of the Ontario Human Rights Tribunal, a tribunal which they wish to abolish. And let's get back to abolish. That is a very strong word, and the opposition is also going to show that abolishment isn't necessary. The government says that these cases are frivolous and that there's no recourse whatsoever. However, the government doesn't tell you that every case that is decided by the Ontario Human Rights Tribunal is subject to judicial review. So that if you believe that you have been treated unfairly by the Ontario Human Rights Tribunal, you can take it to a judge who is trained in the legal ways and they can overturn it. Except the point.
Why wouldn't these people use the real legal system in the first place?
The government is trying to throw out some sort of like the real legal system. This is a real legal system. This is brought forth by the Parliament of Ontario. It is just as real as any other part of the legal system brought forth by the province of Ontario. The second point that they say is that this is expensive. That $7.8 million was spent in determining whether or not, for nuisance claims. $7.8 million out of a total Ontario budget of approximately $100 to $120 billion to protect people's rights. The opposition thinks that, quite frankly, that is a great deal, especially when the rights that are being protected are rights that are being used by minorities, rights that are being used by people who are gay, rights that are being infringed by the police, rights that are being infringed by the education system. And the reason why I use all those examples is because the education system, the police system, schools, these are all cases which the Ontario Human Rights Tribunal has decided and has made a great difference. And the government has come up and said, for example, that, well, they've given you some nuisance cases, 2 nuisance cases, 3 nuisance cases. In 1 second. Every judicial system has a nuisance case. However, just because there are 2 nuisance cases, for example, out of the 3,500 cases that the tribunal sees, it is not cause to totally chuck the Ontario Human Rights Tribunal, throwing the baby out with the bathwater, as the opposition would say. Question.
Can you give me an example of a case where the tribunal made a difference in education?
Yes, the Kelso versus Canada, 1999, the tribunal stated that you cannot allocate resources in the education system based on discriminatory practices. For example, you can't say a school with a primarily black population should get less money than a school with a primarily white population. That's just one example. And the third point which they bring up is that it doesn't do what it's supposed to do. Ladies and gentlemen of the House, in terms of education, for example, it told us that the system cannot contain bias or prejudice or intolerance. In terms of private sports facilities and private clubs, it says that private clubs and private recreational facilities can't discriminate. In terms of organized sports competitions, the tribunal says that you can't discriminate on the basis of gender. In terms of police services, the tribunal has said that you cannot discriminate by race, i.e. racial profiling is not allowed. The tribunal has a strong history of giving rights toward people who are disenfranchised and who are being treated unfairly by those who are infringing their rights. Now, the government is taking quite frankly, they're hacking away when only a fine surgical precision is needed. Because even if the Human Rights Tribunal is a little bit flawed, and every organization out there is a little bit flawed, it does not follow that the only possible solution is to completely and totally abolish it. There is something called reform. I mean, they think that the Ontario Human Rights Tribunal is a horse that broke its leg. The horse broke its leg, you kill it. That's not the case with the Ontario Human Rights Tribunal. You can reform it, you can make it more fair, you can take any deficiencies which may or may not exist and then reform it. So not only does the Human Rights Tribunal do good things, not only does the Human Rights Tribunal protect us where the Charter doesn't, but the Human Rights Tribunal can be reformed. The opposition believes that the government has not made the case for abolition, i.e. it must be gotten rid of. With all of that, ladies and gentlemen, Mr. Speaker, the opposition begs to oppose.
Now, we are going to listen to the government seconder, Margie.
Thank you very much. Now for part 2 of my logical fallacy educational. There's so many to choose from. It was delightful. Let's start with some straw men and some red herrings, shall we? We made a statement. The Ontario Human Rights Tribunal must be abolished. We didn't say the code was bad. The code's fine. The code can be dealt with through the existing real legal system. We said the tribunal was fatally flawed. We didn't say huzzah for discrimination. We didn't say, yeah, let's go out there and put signs up discriminating against people. We think it's bad to discriminate against people. We're saying the tribunal is not only ineffective, it's unfair and it's expensive. It's not a good way to deal with the true issues. So there we have a straw man, we have a red herring, just to keep everybody in the loop. We did have an example that was completely out of bounds, in that the education case brought up was decided in 1999, which was before this tribunal was in fact founded. In our definition, we said as founded in 2008, in the after the Ontario Human Rights Code was amended, when the tribunal gained all sorts of broad and arbitrary powers. That's what we're talking about getting rid of. We're not talking about getting rid of action against discrimination. Although, on a side note, the discriminatory practices with education, as far as I can tell, still continue in the existence of the Catholic school system, in which people are discriminated against in employment based on their religion. So, not so sure the tribunal, even in its older form, did a lot to fix that. I would like to point out, though, that the surreal and Kafkaesque world of the tribunal, and woe be unto you should you ever be pulled in as what they call a respondent. Who will you be facing? You'll be facing people like David Wright, whose background is in labor law, Ken Patterjee, whose background is in human rights law, Keith Benestrel, whose background is in labor law, Anna Chadha, whose background is in disability law. Are you sensing something here? Talk about stacking the deck. Not only are the people who are judging you people who have spent their careers advocating for, on behalf of people who believe they've been discriminated against, they're also going to advocate for the appellant. They're going to advocate against you. They're going to build a case against you. And you might not have done anything, as far as you know. You might have said, your food is kind of smelly, please don't cook it in the microwave. Now, that could have been popcorn. I've been at places where popcorn's not allowed. I've been at places where they're like no fish in the microwave. But we had somebody go to the tribunal and win because she had spicy food in the microwave. And so she was clearly being discriminated against. And they went so far as to try to take the woman, the boss's house, to pay the settlement. They put a lien on it. And it was in the process of sale when the court system finally got a chance to overrule and say, we have no idea where the heck the adjudication came from there, because there is no way that made any sense. So we have no basic threshold. Anybody can come with any complaint. Even if they're eventually dismissed, the tribunal will work on the behalf of the complainant against whoever they complain against to build a case as best they can, even if it's eventually dismissed. And the person who's accused invests time, invests money, may have to make multiple appearances. If you read the decisions, you'll find that frequently the appellants don't show up. And yet, they have to spend all that, and the best that they can get out of it is to go like, oh yeah, never mind, you're not guilty. That's like the best outcome. And it's appalling. It's expensive for what you're getting. You're not getting that many decisions that are actual final decisions. A lot go to arbitration. So let me just say really quickly, we're not saying not to do stuff. We think that negotiated agreements and arbitration is good. We think pursuing through the courts is good. We think that bringing lawsuits are... All of these are good alternatives. And sure, enforce the Human Rights Code, but the tribunal, an extrajudicial system that has no limits on its power and is just spending money like water, is not the way to do it. Not when there's just no boundaries as to what constitutes a reasonable case, what constitutes a reasonable settlement, until you get to the real court system when they're busy overturning these decisions almost as fast as they're made. Thank you.
Now we will have the opposition seconder, Reagan.
There's nothing like being lectured about logical fallacies and then have them replayed for you and repackaged for you once again. Let's talk about a few of the fallacies here. First and foremost, the fallacy or the false dichotomy between the extrajudicial system, such as the tribunal, and the real judicial system, the courts. Ladies and gentlemen, we are a sophisticated, democratic society that follows the rule of law. And throughout our legal system, in addition to courts, we have expert tribunals. The Human Rights Tribunal is just one of the many, many expert tribunals that work within our legal system to provide us all with a legal framework and, yes, support the principle of the rule of law. For example, labor arbitrations are just that. They go in front of an arbitration. When a union and a management have an issue with regards to a collective agreement, they don't go to a judge. They go to a labor arbitrator. And yes, what are the labor arbitrators' backgrounds is? Well, ironically, some of them are actually in labor law. Some of them were former management lawyers. Some of them were former union side lawyers. But they're arbitrators, yes.
So who's the equivalent of the former management lawyers on the Ontario Human Rights Tribunal? Who's pro-business? Who's doing that?
Oh, well, Rajan, the current chair of the board of directors of the Human Rights Tribunal is a lawyer for Ware Folds, and he's admittedly a management side lawyer. Now, so the other tribunals include employment. You have problems with your Employment Standards Act, your rights under the Employment Standards Act aren't being enforced, you can go to a tribunal. It's called the ESA Tribunal. Workers' comp has its tribunal also. So the fact that something is a tribunal, the fact that something as the government says is extrajudicial, doesn't make it bad. And the fact that the Human Rights Tribunal is supported by a tribunal doesn't make it bad in itself. Extrajudicial, that's a misnomer. What it is it's a body of expertise that's been entrusted by the government. In fact, it's been legislated by the government to enforce a specific piece of legislation. In this case, the Human Rights Tribunal. It might come to surprise some of us that lawyers don't know everything, and a lot of judges don't know everything. So there's nothing wrong with having an extra body decide issues that fall under the ambit or the rubric of specific legislation, such as the Human Rights Code. Now, let's talk about a few other things. The Catholic school system debate, red herring, that's a constitutional issue. Let's talk about costs. $7.8 million to process 3,500 cases a year. Yes, the wheels of justice turn slow. But I want to point out one thing. Before the tribunal was reformed in 2008 by the McGuinty government, sorry, in the middle of 2009 by the McGuinty government, cases in the tribunal languished. They sat there for a long time because they used to have to go through a Human Rights Commission who would then decide which cases would then get the right to go before the tribunal. The average time to process a case under the old system was 7 years. So the fact that we have a new system now that's trying to move things a lot faster and it happens to require money while we're trying to work out the kinks in the system should not be a reason to wholeheartedly abolish the tribunal entirely. Now, the other argument that the opposition's come up with is the idea that they want human rights, they want them enforced, but they don't want them enforced by the tribunal as is. They want them to go, they say they should go in front of the real justice system. Well, ironically, 2 weeks ago, the Chief Justice, Beverly McLaughlin of the Supreme Court of Canada, made a big speech at the U of T's law school where she warned about access to justice becoming a privilege of the rich. The fact that certain pockets of the population are able to access government funding is not a bad thing. The fact of the matter is, if there wasn't such government funding, a lot of visible minorities, a lot of gay people, a lot of disabled people would have no access and no ability to enforce their rights. And a right enforced, and a right that one cannot enforce is meaningless. And that's why there's money put aside. It's to help those who would have trouble accessing a court system. A system that on average charges $338 per hour. So before you try to before you accept the government's notion that the best thing to do is take a sledgehammer to the Human Rights Tribunal, I ask you to think about this and realize that all problems in our multicultural, multifaceted society require multifaceted solutions. And that's why the position of the government should be rejected wholeheartedly. It takes a sledgehammer when you really need a fine surgical tool.
Now we proceed to the summations, and I will call the leader of the opposition, Adrian.
Thank you very much, Mr. Speaker. The government has come before you today and has attempted to, with the use of 2 or 3 extraordinary cases out of a possible 3,500 cases that the Ontario Rights Tribunal hears, to paint the tribunal as some sort of anachronistic, expensive, money-eating, rights-trampling monster which deserves to be taken out back and shot. Whereas the opposition does not believe that to be the case. The Human Rights Tribunal does its job. Case after case, year after year, over thousands of cases over years, we have the tribunal has done its job in ensuring that people's rights are protected in the best possible way. The tribunal is just as real, just as solid, and has just as much dignity and legal foundation as every other legal system that the province of Ontario determines to be real and have the force of law. Ladies and gentlemen of the House, Mr. Speaker, the tribunal is effective. The tribunal provides great value for its money so that people can have access to justice and to their rights. For all of these reasons, the government's resolution deserves to fail. Thank you very much, Mr. Speaker.
Now, I would like to call the Prime Minister to provide the government summation.
Thank you. Ladies and gentlemen, we know it sounds scary that we're going to take a big sledgehammer to the Ontario Human Rights Tribunal, whereas the opposition wants to take some fine surgical instruments to it. However, this is absolutely not possible. We have heard from the opposition that it's a real thing, it has a foundation based in law, and it just gets just as much dignity as everything else. Unfortunately, the fact that it's in its own guidelines, it says it's inconsistent. It gives the adjudicators extreme powers to do whatever it wants, prevent hearing witnesses, prevent allowing evidence to come in. It ignores basic legal process. What's the grounds for appeal? It doesn't matter, it changes each time. So we can't just take a little surgical instrument and fix this. It has to go. We have to get back to the real legal system, and I call it the real legal system because they have real laws. They have real rules of procedure that are followed, rules of jurisprudence. If there's a problem of access to justice in this world, as Beverly McLaughlin says, well, then there's going to be a problem of access to defense. If you're brought in front of the tribunal, the government of Ontario will pay for the top lawyers to attack you and will make you go to this for year after year, case after case, and you are not offered legal aid. You are absolutely not. It's completely unbalanced. This can't be fixed with a fine surgical instrument. Not at all. This is expensive to you, the taxpayer, when you're brought in front of it, and it's expensive to you to follow all of these nonsense claims. We've heard this effective. We didn't get any proof. We haven't actually heard any proof of the arguments brought forth by the opposition. What we do have, it's easy to find nuisance cases. And one of the key words you can use to index previous cases is name calling. This is one of the most things that are brought forward to the tribunal. The gears of law turn slowly? Well, the gears of law turn impossibly slow at the rate that the tribunal goes at. And if each one of these are brought forward to the real judicial system with real rules of law and jurisprudence, then they keep getting overturned one after another because the adjudicators of the tribunal just keep going out of their bounds, ignoring legal precedent, ignoring case histories, ignoring laws. We absolutely need a sledgehammer. This is not a Canadian system of justice. The Ontario Human Rights Tribunal must be abolished.
would like to call Jim, the adjudicator of today's debate.
Wow, was this a tough one? Whoa, I don't think I've seen the club do a debate as well as this before. Whoa, whoa, lots of points here. Now, I must say that the way I score is once you've seen a world's debating championship, that's what I mark at 100%. So these guys are well up in the 70s here today. So I could be wrong, but that's what I found. As adjudicator, then I'm prepared to stick my neck out. This was something I really didn't think would work, but everyone obviously did a lot of research, and they were very well armed with an awful lot of stuff. And you can see it even on the points of information. The stuff was backwards and forwards, and people knew what they were talking about. The big thing here was everyone did a very good job, I think. Everyone, the PM set everything up. He proved it conclusively, with no problem whatsoever. The leader of the opposition stood up and he gave it a niggle of a doubt, and he came out with some great alliterations, and it really worked just in style. And then he got into some good logic and some good examples, and the whole thing flowed back to the opposition. And then it went to Margie and Reagan, and the whole thing worked really well. Everyone was on case, everyone was on the ball, everyone was there. It was really expecting it to be a really boring evening. Everything worked extremely well at the debating level, and it was really interesting and exciting. I found that, really, I really did. There isn't really much that I can bug people about. There's some great things here, some Kafka-esque, and what was Adrian's line when he got up. It was really fantastic.
Take it out the back and shot?
Yeah. He wrote it all down. I was just
horse with the broken leg.
So really, I really had to get niggly and picky here to find something that didn't quite work. Everything worked in the first instance, but what was it that it came down to? Well, I'll hold on to that one. Let me just say, the big picture, everyone worked well together, everyone got up, everyone did some good POIs. Is it needed? The government did prove that it wasn't working, it wasn't effective, and they had really excellent examples of it, but the opposition said, well, is that the case to abolish it? And that's really where it hinged. I couldn't find much else to work around to say these guys did a better job than that. It came down to the logic of just because this stuff, and the opposition didn't even get into any sort of contradictions. They said may or may not. I was listening for it, even if this is true. They didn't say that. It may or may not be true. So even that worked when it came to the contradictory side of it. They said it may or may not be true. There's no reason to abolish it outright. So PM, great stuff, good opening. All the arguments, all the information that you got came out very well. The opposition, I didn't write down quite as much with you, but it came across as being you opposed everything very well. Margie, a great Kafka-esque and red herrings and so on, worked very well. And Reagan, I think you did your remit very well, because you got into some real guts of the stuff, which is the legal aid aspect, which is another turn on the value. One man's poor value is another man's legal aid. Wheels of justice turn slowly. Yes, the government had already proven it was really not acceptable, the speed of it, but it's a wheels of justice turn slowly. Okay, I can buy that. And it fills in holes in the justice legal system. That seemed to work. So, was the government's argument proven? Yes. Was the opposition's arguments disproving the government. And I came out at the end of the day saying that the government didn't quite prove definitively that it had to be abolished, and I would go along with the surgical strike of the opposition. And I gave, what was it, 64 to the government and 72 for the opposition. So I gave the debate to the opposition. And Dean would like to actually discuss some of the personal wordings and how each person brought up various parts and how that fitted in or otherwise with the debate itself. Dean?
Yes. Thanks. Thanks, Jim. I'm not going to spend a lot of time because Jim's basically dealt with the meat and potatoes part of it. I'm going to give you the gravy, as it were. And
Someone's found the gravy.
That's it. I found the gravy. That's it. Welcome to City Hall. Just to reiterate what Jim said, this was a fantastic debate as far as the action and the spellbindingness of it, and for such a potentially dry draft topic. And I think that came out because Dave was very clear about his definition, very clear about his 3 big points. There was a sort of a minor point as well. And I think as far as the language goes, that's what also got me hooked on what was being said. I like the they called it a para-kangaroo court, and talked about flimsy issues and hurt feelings, and just the frivolous cases and the issue about the man claiming a disability because of his alcoholism. So just very striking examples that way. Adrian coming back and highlighting again the specifics and in fact addressing both points of information by the government. Bang and bang. It's like you planned it ahead. Okay, I'm going to ask you this. I'm going to write it down. And he had it. Bang, boom, just like that. And that's amazing for a point of information as well. With such a complex and convoluted subject, to be able to pick those issues out. The Margie as well coming back, bringing up the Catholic school system. Again, this Kafkaesque idea, and I'm picturing, you know, the government and overseers and the like, and then fish in a microwave. I'm never going to think about fish in a microwave quite the same way anymore. So that worked really well. And Reagan coming out, as a lawyer should, talking about the legal aspects of that, and being very firm about it, and how extrajudicial matters can be dealt with through other tribunals, as well as the legal system. And the summations were great as well. Again, winding up, and I have to give Adrian's quote: "The money-eating, rights-trampling monster that needs to be taken out back and shot." Madly trying to write it down. Because I figured it's a summation, so he's going to be say stuff. So that's it, a big T-shirt for that. And again, and the summations were great. They actually summed up the stuff that had been said. And there was an issue about name calling that was sort of brought up. We might have verged on a new sort of slant on things, but nonetheless, just a firm way of summing up the whole evening by both of you. And it was, I think, that's what made it tougher too, was there were just so few weak points on both sides to you know, and sometimes it's, oh, forget it, easy, that side got it because, and Jim and I had to struggle with the awarding of, okay, well, who's going to get it? What's your gut feeling? Okay, numbers and the like. So congratulations to everybody for a job really well done on that. And as far as the, that's it. As far as the best speaker goes for this evening, I'm awarding it to Adrian.
Now, that concludes our debate of the day.